Welcome to Juristally, and today we are going to talk about Information Technology Rules 2021, which were made recently about intermediary guidelines and digital media ethics code. These rules broadly deal with social media and over-the-top OTT platforms. These rules have been framed in exercise of powers under Section 87 Clause 2 of the IT Act 2000 and the supersession of the earlier Information Technology Rules 2011, which were again about intermediary guidelines. These rules seek to provide compliance of law and a grievance redressal mechanism for users of social media platforms, messaging applications, streaming services, and also digital news publishers. The government contemplates controlling hate speech which gets proliferated through these platforms and threatens national security. However, critics pointed out that the question of strict regulation of digital media will lead to restriction of free speech and undermining of democracy. Now, let's just know a few things that are to be understood. Need for digital media regulations ensuring compliance of domestic laws. Major digital media platforms operating in India are of foreign origin. The rules emphasize the need for these social media intermediaries and online content providers, whether for entertainment or informative purpose, to strictly comply with the Constitution and domestic laws of India. Setting accountability. It extends its approach to instill a sense of accountability against the misuse and abuse of social media users and is the first of its kind to bring social media use under the regulatory framework of Informational Technology Act. Bringing uniformity. There are many laws to combat unlawful content that are already in that place. The recent rules contemplates bringing their uniform application. Two-thirds social imperative. It lays a special emphasis on protection of women against the progression of sexual offenses on social media. It also contemplates a check on growing fake news and hate speech. Now let's just understand the background of information technology rules. In 2018, the Supreme Court has observed that the Government of India may frame necessary guidelines to eliminate child pornography, rape, and gang rape imageries, videos, and sites in content hosting platforms and other applications. In 2020, an ad hoc committee of Rajya Sabha laid its report after studying the alarming issues of pornography on social media and its effect on children and society as a whole and recommended for enabling identification of first originator of such content. The government brought video streaming over the top OTT platforms under the ambit of the Ministry of Information and Broadcasting. Now let's understand the new guidelines of social media and intermediaries. Categories of social medias and intermediaries are divided into two on basis of number of users on social media platform. The first one is social media intermediaries and second is significant social media intermediaries. Intermediaries shall appoint a grievance officer to deal with complaints and share the name and contact details of such officers. Grievance officers shall acknowledge the complaint within 24 hours and resolve it within 15 days of its receipt. Intermediaries shall remove or disable access within 24 hours of receipt of complaints of content that exposes the private areas of individuals, show such individuals in full or partial nudity or in sexual act, or in impersonation, including morphed images, etc. Such complaint can be filed either by an individual or by another person on his or her behalf. Intermediaries need to appoint Chief Compliance Officer, a nodal contact person, and resident grievance officer, and all of whom should be the resident of India. Intermediaries need to publish a monthly compliance report mentioning the details of complaints received and action taken on the complaints as well as the details of contents removed proactively. Significant social media intermediaries providing services primarily in the nature of messaging shall enable identification of first originator of the information. Required only for the purpose of prevention, detention, investigation, prosecution, or punishment of an offense related to sovereignty and integrity of India, the security of state, friendly relationship with the foreign states, or public order, or of incitement of an offense relating to the above or in relation with rape, sexual explicit material, or child sexual abuse material, punishable with imprisonment of the term of not less than 5 years. An intermediary, upon receiving actual knowledge in the form of an order by the court or being notified by the appropriate government or its agencies through authorized officers, should not host or publish any information which is prohibited under the law in relation to the interest of sovereignty and integrity of India, public order, friendly relationship with the foreign countries, etc. Now let's understand the internet intermediaries and protection afforded to them under law. Internet intermediaries are entities which perform various functions including the facilitation of exchange of information and online communication. For example, Facebook, Twitter, and internet intermediaries. A user registered on Facebook can share information with his connections without same being edited by Facebook in any manner. This passive law adopted by Facebook is what in essence enables it to be classified as an intermediary. Under Section 79 of Information Act 2000, intermediaries are guaranteed protection from incurring any liability for third-party data available on their platforms by hosting by them. This protection is essential as various intermediaries such as Facebook, Twitter, or YouTube do not monitor the content posted by the third-party users on this platform. However, if any such content uploaded by a third party user is in violation of any law, the intermediary does not incur any liability for such information. Imagine a situation where a third party user posts defamatory content on Facebook. Now, if Facebook were to be held liable for such a post, it would necessarily mean that Facebook, as a passive platform enabling online communication, is required to first scrutinize the content being uploaded on its platform. This not only goes against the model of operation but also hampers free flow of information. This could also result in censorship of information where legitimate content may also be taken down on apprehension, resulting in third party users' freedom of speech and expression being stifled. Section 79, which is recognized as safe harbor provision, enables intermediaries to function freely without having any such obligations to monitor the content before it is uploaded. However, the protection offered in intermediaries during Section 79 is conditional. One of the conditions prescribed under Section 79 is an intermediary is required to observe due diligence while discharging its duties and observe guidelines made by central government in this regard. Now, the term due diligence is not defined under Information Technology Act 2000. Neither does the Act prescribe that what the standards of due diligence required to be followed by the intermediaries. This is where guidelines framed by central government came in. Now let's understand what happens if intermediaries do not compel. According to Rule 7 of 2021 rules, if any intermediary fails to observe any of the rules laid down, it loses protection afforded to it by Section 79 of Information Technology Act. Simply put, this would mean that the intermediary like Facebook or Twitter would be open for liability if the third party user posts unlawful content on this platform. If publication of such information amounts to an offense, the intermediary hosts such information would be punishable under relevant laws in absence of protection offered under Section 79. Thus, non-compliance of 2021 rules would expose the intermediaries to significant liability. It is unlikely that they would be banned from operating in India for such non-compliance. It may, however, render their operations non-viable as they may be required to proactively monitor information uploaded on its platform so that to avoid incurring liability. Only time can tell what the course of actions these intermediaries adopt. In the meantime, one can only hope that for the sake of millions of people using these platforms, The enactment of 2021 rules will not affect the way these platforms operate. By concluding, I would say that regulations has been an important place in liberal democracy. However, given an environment where people are sensitive to content, the regulatory mechanism with the scope of strong government intervention could always be an operational nightmare and hamper creativity and freedom of expression. Hoping that you'd find this topic informative and helpful. Do not forget to like, share, and comment on your views on this topic and subscribe to our channel Juristally.